Welcome to the Binary Era. I am your host, Olga Rivera Martinez, and digital platforms normally characterize themselves as these multi-dimensional players that produced their impacts in many different aspects of our economies, livelihoods, and fundamental rights. And some scholars have even characterized big tech digital platforms as rule makers within their own environments, which normally escape different sets of rules ranging from data protection to competition law. And in turn, this entails that different fields of law are impacted and they also must respond promptly to the challenges posed by these digital platforms. And to observe and analyze this overlap, I have with me today Belle Beems. She's an assistant professor in EU competition law at Leiden University. And in her PhD, she examined what institutional frameworks and also cooperation mechanisms can guarantee so as to ensure a coherent enforcement of competition law, the DMA, the GDPR, applied to personal data markets. So welcome to the Agora, Belle.
Thank you so much, Alba, for the kind invitation. I'm super happy to be here and I'm very much looking forward to the discussion.
And to start the conversation, I just wanted to provide a bit of an overview of what these overlaps between GDPR, TMA, competition law are about. So according to the Court of Justice in Big Post, it basically explained and outlined that the same player can be sanctioned 2 times for the same facts based on different laws as long as the authorities protect different legal interests and coordinate and communicate between each other. So from your knowledge and also your experience from your PhD, is this the right approach? Was there even a simpler solution to try to reconcile these different legal interests in a more efficient manner on the side of the Court of Justice?
Yes, very interesting questions, and we dive right into it with the bis in idem, which is a topic I studied indeed in my PhD as well. For ne bis in idem, first and foremost, I think it's important to highlight what it can and cannot do. Right? Ne bis in idem is a very important principle in a field where you have multiple legal frameworks being applied at the same time. Those different frameworks protect partially different, but also partially overlapping interest goals. They pursue similar yet different objectives, different sides of the medal. And this is where ne bis in idem comes in. So first and foremost, from my perspective, ne bis in idem is not as such a principle that can streamline the overlap between those different fields. We need much more. Ne bis in idem is more a guardrail or a safety net to mitigate unintended consequences of different legal frameworks being applied at the same time. So that's a nuance I would like to make. Then to zoom in on the case, B-Post, also Noordzucker, I think it's really important that the Court of Justice in those cases aligned the application of the ne bis in idem principle across EU law. I think that in the end simplified the field. Of course, as a result, it's not necessarily enough to argue that a framework protects different legal interests. That's now part of a broader proportionality assessment in which we also look at coordination and cooperation. And I think this is a reasonable approach. Of course, it's complex, but the entire field is complex. So I don't think within the boundaries of this case and within the boundaries of the ne bis in idem principle, the Court of Justice had a genuine opportunity to simplify the entire regulatory landscape.
Picking up on what you were saying, actually, so looking at the other side of the coin, so actually coordination and cooperation, the Court of Justice has also discussed this and fleshed out this principle of sincere cooperation within the Meta case, where basically the Court of Justice analyzed the German Competition Authority's application of the GDPR in the context of competition law. So I wanted to ask you this, because sometimes when I'm talking, for instance, with people specializing in digital constitutionalism, they do not quite know what the principle of sincere cooperation means in practice. So I wanted to ask you, what does that actually look like, and what main problems do you identify with this overriding principle of sincere cooperation?
Yeah, again, a super interested and rich question. So I'm going to try to break it down a bit, right? Because this question has so many dimensions, and I'm sure we can talk for like an hour about this question only. First and foremost, the principle of sincere cooperation is, of course, not only relevant in the context of cross-disciplinary collaboration. So what do I mean by cross-disciplinary collaboration or cooperation? I mean cooperation between enforcers of different fields of the law. In this case, competition and data protection enforcers. It is also relevant in the boundaries of one and the same legal field, right? So for instance, the entire European competition network is grounded in this broader principle of sincere cooperation. Also, the more elaborate framework for collaboration between data protection authorities with the lead supervisory authority, etc., is founded in this general principle of sincere cooperation between institutions and enforcers of the different member states, but also in the vertical relation between the EU institutions, European Commission, and national enforcers. So it finds a much broader implication, and in that sense, it's really important in general for the functioning of the partially decentralized parallel enforcement structure of the European Union, also beyond this digital debate. Then what does it mean for collaboration between data protection and competition authorities? With Meta Bundeskartellamt, we see a super clear need for collaboration, cross-disciplinary collaboration between those authorities, right? Because as you say, competition authorities are now allowed to take certain data protection considerations into account in their competition law assessment. So I think from my personal perspective, this is a very reasonable approach, because without allowing competition authorities to take into consideration data protection or privacy, the entire field would become irrelevant for personal data markets, right? Where personal data is precisely the most important competitive parameter. So from that perspective, I think it's a very logical, also a very necessary development. Of course, it triggers then all types of questions, and some of those questions are institutional, right? Because different authorities get into each other's territory. And then the question arises, what should we do with this? Authorities should somehow collaborate. And this collaboration can work relatively well, especially in the context of one and the same member state. So if we look at the Netherlands, for instance, there are a lot of protocols that allow collaboration between the Dutch DPA and the Dutch competition authority. The same goes for Germany. They are, for instance, allowed to exchange confidential information. What is far more complicated is cross-disciplinary and cross-border collaboration. And still there's a need for this more transversal interaction, as the GDPR is enforced according to a different institutional structure, right? It's more of a country of origin mechanism, where the country in which the data processor, the data controller, has its main European establishment. And that triggers a need for collaboration, for instance, between the Irish Data Protection Authority and the German Competition Authority in this case. And that's far more difficult because, as the European Court of Justice also makes explicit in this case, neither the framework of European law nor the GDPR provides for any meaningful structure to achieve this collaboration. The Court of Justice then falls back on the principle of sincere cooperation, and I think that's a reasonable approach. It's all they have, and this principle obviously also covers cross-disciplinary cooperation structures. So in that sense, I think it's a very positive development that the Court of Justice now explicitly highlights this need for cross-disciplinary collaboration. And I think that's really a landmark decision in the development of those mechanisms. Then to go to your next question, is it enough? All right. From a practical perspective, is it enough? I don't think so, because still it's a rather generic obligation to cooperate. The Court of Justice derives some more concrete obligations from this general principle, but still it remains rather vague. What are the main problems, in my view? First of all, the absence of a forum. It's not clear where authorities should coordinate, whether it's sufficient that the individual case handlers contact each other, whether this is something that should take place at the board level. So that's an open question that should be clarified. And secondly, and even more problematically in my view, confidential information. There's at this point no legal basis whatsoever to exchange confidential information in a cross-border setting, and that's something that should be resolved.
So a few thoughts on that. First of all, we already explored within the channel this idea of the lack of a legal basis for exchanging confidential information with Sebastián Barros on a previous episode. And I was also going to ask you whether there's also an additional problem and an additional obstacle, which is basically that in the absence of form, maybe we could include also absence of a clear timeline. So it's not always clear when the competition authority or the data protection authority should send this request to, for instance, consult or cooperate. So what is the most appropriate moment to do that? That's not clear. And then just out of curiosity, wanted to ask you whether in the particular case of the German competition authority's decision, do you think that it really implemented this principle of sincere cooperation correctly?
Yeah, so on your first question, the timelines, absolutely. That is an additional problem because now we know there's an obligation to submit information to respond within a reasonable time frame, right? But what is reasonable? And here, if we look at experience in the context of data protection law, for instance, we now see the introduction of a procedural GDPR regulation precisely because timeframes, amongst others, are insufficiently clear. Then if we look at what we have in the context of the GDPR, it's already far more elaborate than what we have under the Meta Bundeskartellamt case. So that's definitely something that must be clarified, that must crystallize in the future. On your second question, what was it again?
The application by the German Competition Authority of the principle.
Yeah, according to the Court of Justice, it was enough. Right? In the end, they complied with their obligations. An additional problem, mostly for researchers, is that this collaboration is often super intransparent. Right? So it's really hard to judge to what extent, when they contacted each other, what they discussed. So that's a bit more difficult to discuss from an outsider perspective. The outcome apparently was sufficiently coordinated. The process, hard to tell.
And I would also thank you for answering the first two questions, which were actually about what should the rules say, which you don't really tackle within your research because you have a different approach. So your central question within your research is who should do what in the practical side of things. So why have you built your research around that question, and why is this a better approach to ensure that everything works out better in practice?
Good question. Again, I don't think it's a better approach necessarily, right? I think we need the two. Firstly, we need good rules. So we need to have a lot of discussion on how should we shape the rules, how should we shape the substantive frameworks. However, if we have good rules, they must be applied. Otherwise, they become a dead letter. And for this application, for enforcement institutions, and therefore also institutional design, the who should do what question is key. I chose to focus my research on the second question because I think it's a bit underrepresented in the current academic debate. Not so much because it's a better question in and of itself, but because I genuinely believe that we need both and that we have more of the former at the moment. So we, but also policymakers, even lawmakers at the European level, discuss very intensively and in depth how the legal frameworks should evolve, which rules do we need. However, if we don't enforce those rules, in the end, the practical outcome won't be efficient. And that's why I chose to focus on institutions.
I believe that we met in Düsseldorf, and I already talked about this idea of decentralization, and I have been working on it for quite some time now. For instance, the DMA is not a decentralized enforcement system, it introduces a centralized enforcement system, but increasingly and progressively we're seeing that the EU digital acquis is really steering towards decentralization, and different types of authorities want to handle the same problems with different approaches in mind and assuming different roles to enforce, in some cases, one single rule or several. So I wanted to ask you whether designing these rules with the decentralized enforcement system in mind is really setting authorities up for failure, or isn't it? And is there, I would say, a version of too much coordination taking place where enforcement becomes so aligned, so centralized that it loses the useful and distinct perspectives of integrating this distinct perspective of the different authorities, or, for instance, that it becomes politically captured, this type types of findings and the different interactions taking place within the enforcement framework.
Yeah, so I'm also working quite a lot also with my colleague Jasper van der Boom on the decentralization question. So I'm more than happy to hear your thoughts as well, right? Because we work more or less on the same topic here. Firstly, and fully transparently, I'm not against decentralization. I'm very much in favor of involving national authorities because I do genuinely believe they have a very meaningful role to play. And I think they've proven in the past that they have a part to play by experimenting, by applying novel rules that then can inspire the European framework. And also, much more practically, by offering a lot of capacity, right? They have a lot of regulatory capacity, most authorities at least, and they're willing to act on digital markets. So I would say it is, and it remains important to leverage that capacity and that willingness to intervene. So I do think we should leverage their position and make the best use of it. The question is then, of course, how do we do this? So how can we set up a system that allows the European Union, the broader framework, to benefit from experiments at the national level without losing too much on uniformity, incoherence, etc. And that's precisely where collaboration mechanisms come into place. From that perspective, I think it's a used opportunity that the role of national competition authorities, for instance, is only discussed at a relatively late stage of the legislative process for the adoption of the DMA, because their role is simply too big to ignore them. Also, you mentioned regulatory capture, and that's a serious problem, especially nowadays. Independence is under severe attack outside of Europe, but also closer to home we find problems. And there I would say a decentralized system also offers significant benefits, right? It embeds some checks and balances in the system without concentrating too much power with one and the same entity, the European Commission, for instance. So from that perspective, it could also do something meaningful if the European Commission, for instance, would be under too much pressure from Washington. So I am in favor of a decentralized approach, provided that the mechanisms for collaboration and coordination are sufficiently effective. Right? What we don't want is the booking.com situation where different authorities investigate without any coordination and reach different outcomes. That's undesirable for the development of the field of competition law as such, but it's also a waste of regulatory resources. So my answer is pretty nuanced here. Yes, I'm definitely in favor, provided that those collaboration mechanisms are sufficiently developed, that authorities talk to each other already in the case allocation phase of enforcement. Then I'd say, yes, definitely stick to the decentralized model.
So responding to that, I think that I don't really like picking sides in favor or against or a form of regulatory design, but I will say this, and this is something that I think really mirrors what you were saying, is basically that there are trade-offs involved with setting out a decentralized enforcement system. For instance, with competition law, we have been seeing that. The example that comes to mind is that of Meta's AI chatbot integrated into WhatsApp. And then because the Italian competition authority intervened, it triggered the European Commission's intervention later on. And now we have like two different sets of interim measures being imposed on the same company. And I don't really know whether Regulation 1/2003 was really designed to deliver those types of results. And we have to acknowledge that, of course, decentralized enforcement may also crystallize in these overlaps between national competition authorities, in this case, resolving cases with different opinions in mind as the European Commission. And picking up on your booking example and moving away from competition law and moving towards the DMA. Another example, not of the MFN case, but rather of bookings. So the Spanish Competition Authority also intervened after the DMA entered into force. Booking was not yet designated as a gatekeeper, but the Spanish Competition Authority decided to fine Booking for the unfair nature of the conditions that it imposed on the hotel sector in Spain. And I think that those types of decisions also conflict and conflate the centralized enforcement system that now the DMA has, and I don't know whether we can really draw out the same conclusions for the decentralized enforcement system coming from competition law to the DMA, because I think that they are two different scenarios that we must contrast, and national competition authorities, at least we can acknowledge, and I agree with you that they have this additional capacity to investigate cases and to produce their findings, but I don't think that the DMA's enforcement, that the European Commission should outsource its enforcement of the DMA to national competition authorities, because that's not the role that the DMA provides them for. So I think that my view is a bit more of trying to understand what the unintended consequences of picking one system or the other are going to provoke. Do you have a response to that?
Absolutely. Okay. You're totally right. It's context dependent. It depends on the framework, the amount of regulees, etc. What is better, decentralized or centralized enforcement system? In competition law, I definitely see a role for national competition authorities, and I think that's where we agree. For DMA enforcement, I would potentially see a role for national competition authorities in the future, because I think this balance, and I agree totally, it is a difficult balance, right? Because decentralization brings obvious benefits, but it always brings a risk of incoherencies, of different authorities going in different directions, etc. But I do believe that in the future, so only once the European Commission gains significant experience with DMA enforcement, it would be meaningful to explore the possibility of further decentralization. Also because I think that somewhat paradoxically, it may result in more incoherencies to leave them out if they want to play a role. Let me explain, because it may sound a bit confusing, right? If the National Competition Authority wants to do something that overlaps slightly with the DMA, now to act proactively, they can either request the European Commission to start, but the ball would still be in the court of the European Commission, or they can start a competition law case, which then results in tensions between the different framework. In my view, and again, only after we gained sufficient experience with DMA enforcement, if the national authorities could start a case, we keep it within the territory of DMA enforcement, which in the end could be more coherent. Of course, again, and that's super important, we need sufficient safeguards. So I would say if we go down this path, we definitely need some things that resembles Article 11.6 of Regulation 1/2003, where the European Commission can always take over if they think the national authorities go beyond what they should be doing, or if they somehow notify or notice that different authorities go different directions. So I agree, without those safeguards, it would be a mess. But I do believe that the authorities could have a role to play, provided that we firstly have enough experience with DMA enforcement, that the authorities know how it works, and that secondly, there are sufficient safeguards in place that allow the Commission to intervene in a very early stage of proceedings to avoid conflicting decisions.
So a quick follow-up on that. What would sufficient expertise mean to you? You also considered to have this two-tiered approach. So until we get to sufficient expertise, we have this model, so the centralized enforcement system, and how would we transform to the next level, to the more centralized, so through a DMA amendment, for instance?
Yeah, that's hard to quantify, of course, at this point in time, because I don't think that we can argue like we need 10 cases on each obligation and then we know that we're there. I think it's a more delicate process. It's a process from which we can draw experience from the centralization of competition law, right? There we also saw a gradual trend towards decentralization and an increased role for national competition authorities. So I wouldn't be able to pinpoint an X amount of cases or even a very specific point in time, but I do think it's something that should be part of the academic debate and also part on the discussions on DMA revision in the future.
And to end the conversation, I'm going to the broader perspective of how digital rules get enforced. I also wanted to ask you about these ideas that have been floating around with regards to the possibility of a single European super regulator being created to try to assume enforcement in digital markets. So what are your thoughts on that?
First and foremost, it's a very interesting suggestion, right? But it would be obviously a huge simplification. However, in practice, I see some problems. The first problem relates to policy coherence, right? Because this authority would be responsible for a vast amount of very different regulations. And that doesn't mean all coherence issues are resolved by creating this entity. Problems become internal problems instead of external problems. And then we would also have the same discussion, just focusing on different departments of this super regulator. Secondly, I see a big problem with competition law, because the Commission's role in competition law enforcement is laid down in the treaties. So either this authority would not be able to enforce competition law, which would leave us with very similar discussions as the ones we're having today, or we would need a treaty revision, which is not feasible at the moment. From a simplification perspective, I see some benefits. However, in practice, I don't think it will resolve the practical issues we're having, and I don't think it will be a feasible solution to adopt in the near future.
Okay, thank you so much, Belle, for answering all of those hard questions which not everyone dares to face. So thank you so much for that. For the audience, if you have liked the video, do not forget to subscribe, to like, to rate the video. Also drop any comments you have below. And yeah, with that, Belle, I only wanted to thank you for joining us here in the Agora and sharing your insights and your thoughts.
Thank you.
Thank you. Bye-bye.